I believe we are now good to go.
Is that my cue?
Yes, sir, Mr. Chair.
All right. Welcome, everybody. Obviously, very sorry we can't be together in Asheville, but it is good to see everybody this morning. I hope you and your families are well. This is the July 2020 meeting of the Authorized Practice Committee, and I will read the ethics statement. It is your duty to avoid conflicts of interest and appearances of conflicts of interest in performing your duties as a member of the Authorized Practice Committee and North Carolina State Bar. Is any member of the committee aware of any personal conflicts or appearances thereof with respect to the matters before this committee today? Okay. Hearing none, seeing none, we will proceed. Give you a little bit of a, well, first, let me recognize Josh. Josh is going to introduce, I think, one of the interns from the State Bar.
Did Josh get back on?
Yeah, I'm back on, David. Thank you, Kevin. Normally we do this in person, but obviously, since we can't, let me introduce you all via Zoom to Brian Atari. He was the State Bar's intern this summer. He is a rising 3L at Campbell. He is number 3 in his class, and he has done awesome work for us this summer. We've been very lucky to have him. He is kind of boring and really intelligent. He's also getting married in December. So Brian, if you're on, go ahead and tell everyone your favorite color, and then don't say anything else.
A darker blue, not quite a navy, but somewhere in that range. But thank you all for letting me join.
And I was getting ready to say welcome, but anyway, welcome anyway, Brian.
Thank you.
So a little bit of a heads up as to how we will proceed. As the agenda suggests, we will do the report from the prepaid legal plan, discuss some proposed rules. We had 2 decisions on for discussion. One of those, Mr. Fuller's case, has been continued, and then we will move to the consent agenda. I am aware of 2 matters that will need to be pulled for discussion, and then we'll give you an opportunity for those of you who want to pull any others from the consent agenda for specific discussion. We can do that. So with that, I'm going to recognize Savannah, excuse me, to discuss the prepaid legal plans.
Hey everybody. So I'm going to start with our just regular report. I have 1 action item for prepaid legal services plans. We had 51 plans add new participating attorneys during the first and second quarter of 2020. And 1 plan changed its or requested to change its registration address and phone number. That amendment was also accepted for registration. 2 proposed plans submitted initial registration statements during the first quarter, or the first and second quarter. 1 was accepted for registration and 1 is still pending review. We also had 3 proposed plans resubmit applications for registration. 2 of those were accepted for registration and 1 was not. The plan that was not accepted for registration has since submitted another proposed application, and that's still pending review. And then for our action item, each year, every prepaid legal services plan is supposed to submit an annual registration form and pay an annual registration fee. 2 plans failed to do that last year. 1 is My Family Plan LLC. We're fairly certain the plan owner is deceased. That came back on a follow-up letter that I sent the plan owner. So we would like to issue a notice to show cause why the plan's registration should not be revoked, that we plan to serve on the executor of the plan owner's estate, because we really don't know whether that plan is still operating. I can't get a hold of them on the registered telephone number, but otherwise I'm not sure what's going on with that plan. So do we need to take a vote on each item? if there's two plans? David?
I think it'd probably be best.
Yeah, we do.
Okay, so that's my recommendation for the My Family Plan LLC, is that the committee instructs staff council to issue a notice to show cause.
And the chair will entertain a motion.
So moved.
Is there a second?
Second.
Any further discussion? All those in favor of the motion, please indicate by voting yes in the participants tab. And any opposed, please vote no using the participants tab.
You have a total of 21 yeses and 0 nos, Mr. Chair.
Okay, thank you, Brian. All right, Savannah.
Okay, and the second plan that did not respond or did not file a registration annual renewal was General Parks, and the plan owner indicated that that plan is no longer operating in North Carolina. So I would recommend that we can skip the step of issuing a notice to show cause and ask that the committee request the council to enter an order revoking the registration of the plan pursuant to Rule 312 of the rules concerning prepaid legal services plans.
Okay, the chair will consider a motion in that regard.
So moved.
Is there a second?
Second.
Discussion. All those in favor vote by clicking yes, and any opposed vote please by clicking no.
You have a vote of 21 yeses and 0 nos.
Okay.
Okay, and the second half of our prepaid legal services kind of report is about the prepaid legal services plan rule amendments. There was a subcommittee that introduced those proposed amendments to the rules concerning prepaid legal services plans to the committee in January of 2020. Those amendments were published for comment after the January meeting, and we received some questions and comments from Mitch Armbruster. He's an attorney representing Prepaid Legal Services Incorporated, and I think he's on our Zoom call with us today. Mr. Armbruster proposed including a deadline in the text for the rules for registration determinations and requested clarification of some things like whether each plan has to be registered or each plan owner, and whether the state bar would accept electronic filings. He also requested some clarification of some language in our proposed rules that referenced attachments in two separate proposed rules. Our subcommittee, the members are Ligon Bundy is the chair, Andrea Kapua is on the committee, and Jerry Collins is as well. We got together again and discussed Mr. Armbruster's letter and his request for clarification. And we decided to make two technical modifications to our proposed amendments to add some clarification to our prior references to attachments. The State Bar staff, myself and Catherine, responded to Mr. Armbruster's letter, and all of those materials are included in your materials today. Our modifications to our proposed amendments do not require republication because they were not substantive, they were technical. And it's the subcommittee's recommendation that the committee recommend to the AP committee recommend to the executive committee that the amendments be, sorry, I want to get this right, that the amendments be submitted to and adopted by the council. Ligon or Mr. Armbruster, do you have any additional comments that you would like to make about these proposed amendments?
Savannah, good morning. This is Mitch Armbruster. I don't want to make any substantive comments. I just wanted to thank the entire committee for their work on this issue and appreciate you continually responding with my questions, even when they're they evidence that I didn't know maybe what was going on. I really appreciate the committee's work on this, and on behalf of my client, Legal Shield, we appreciate it too. Thank you.
Thanks, Mitch.
I don't have any further comments. I think you covered it well.
Okay.
Um,
Savannah, thank you for the report. Ligon, thank you, and the subcommittee members for all your work. And at this point in time, the chair would entertain a motion.
Okay, I'll move that the Authorized Practice Committee recommend that the modified proposed rule amendments regarding prepaid legal services plans be submitted to and adopted by the.
I'll second that if it needs a second.
All right, thank you, Jerry. Any further discussion, questions, or comments by any committee members?
I'd just like to recognize the hard work of Andrea Capula and Jerry Collins, and particularly Catherine Jean, and particularly Samantha, who had the laboring oar on getting all this done. So.
Thank you, Ligon. Anyone else? Okay. All those in favor of the motion, please indicate by clicking yes. And anyone opposed to the motion, please indicate by clicking no.
Looks like you have a vote of 20 yeses and 0 nos.
Okay, thank you, Brian. And thanks again to all the folks working on this issue. We will now move into the issue involving Miss Tammy Alexander. And just so everyone knows, my understanding, the protocol is Miss Alexander has been waiting in the virtual waiting room. And now Brian or someone will allow Miss Alexander to enter. We'll give her an opportunity to discuss this matter. Or we'll let her in, and then Josh or David. Josh, is this yours?
No, this is mine.
Okay, we'll let David give a brief explanation of this matter. We'll then allow Ms. Alexander a brief opportunity to address the committee, and then we will consider it from there.
I'm letting Ms. Alexander into the meeting right now. All right, Mr. Chair, I believe Ms. Alexander is in the meeting.
Okay. Ms. Alexander, can you hear me? Ms. Alexander, can you hear me?
From what I can tell, Kevin, she has not connected her audio and her camera is not on. So
Okay.
I am going to try to contact her individually.
Okay, why don't we?
I apologize for this.
That's okay. We'll stand down for 30 seconds or so, see if we can get this figured out. This is unfortunately our new normal.
It looks like we lost her, Kevin. I'll say I've noticed that she's been going in and out of the waiting room, so I don't know if her connection is great. David or Josh, do you have her contact information that we could potentially reach out to her and suggest that she call in?
I believe we have her email information. Lori or Brittany, can you send her an email?
Her telephone number is at the bottom of her response to the letter of notice, in addition to her email address.
It's also on the complaint.
Okay.
Kevin, while we figure this out, if you wanted to potentially move on to a different matter, this one may take a while to.
Yep.
to
Good
sort through.
suggestion, and that's what I was getting ready to do. Thanks, Brian. Why don't we move on to the consent agenda? There are two matters that individuals would like to be heard on. That's number 17, Wallace Washington, and number 22, Andrew Carabas. And so those two matters will be pulled from the consent agenda for consideration. So the question at this point is, are there any other matters on the consent agenda that any of the committee members would like to be pulled for individual consideration? If so, please raise your hand and let us know.
See, Mr. Savage has his hand raised.
Okay, Warren?
Number 12, Edgar Jimenez.
And
Ligon Bundy has his hand up as well.
yes.
Okay. Ligon?
Number 10, Seneca Jacobs. Number 12, Edgar Jimenez. We could discuss those.
Okay. Any others? All right.
I don't
Seeing
see any other hands.
All right.
Kevin, would you like me to, do you want to address those, or do you want to address Mr. Washington or Mr. Carabas first? They are in the waiting room.
It doesn't matter. Why don't we go ahead and take the ones who folks are waiting, was in the interest of their time.
All right, I will first admit Mr. Washington.
Okay.
Mr. Washington, can you hear us?
I think he's muted, Brian.
Yes, like you are on mute, sir. There you go.
Now I am. Can you hear me okay now?
Yes, sir.
Hi, good morning. I'd like to say good morning to the board and thank you for an opportunity to address you briefly. I would like to ask that that this be dismissed. And the circumstance surrounding that request or dismissal is.
Mr. Washington, excuse me for interrupting, but let me just introduce myself. My name is Kevin Williams, and I serve as the current chair of the Authorized Practice Committee. So welcome to our virtual meeting this morning. Before we hear from you, what I'd like to first do is call on the State Bar Council to give a brief explanation to the committee about this matter, and then we'll give you an opportunity to respond to the committee. Is that okay?
That's fine. Thank you.
Thank you and welcome.
Okay, this is the matter in which Mr. Washington communicated with the Charlotte Mecklenburg school system on behalf of the parent and identified himself as representing the parent as an attorney, and Mr. Washington is licensed in Georgia only. He's not licensed in North Carolina. So this matter involves him trying to represent a North Carolina resident on a North Carolina matter when he's not licensed here.
Okay. With that, the chair will recognize Mr. Washington.
Thank you. Once again, I'd like to thank the board again for this opportunity and give some context to the situation concerning the Charlotte Mecklenburg School Board system. What happened was a cousin of mine that lives in Charlotte reached out to me in February because her son was not allowed to march in a graduation ceremony scheduled for the middle of March. She invited a lot of family members, including our 90-year-old aunt and some other family members from the Charleston area, which we're all originally from. There was no money that ever exchanged hands. She just wanted me to reach out. I worked for a company called Crown Castle. We're in the telecommunications industry. And I had worked in the past with the Charlotte-Mecklenburg School Board attorneys regarding some cell towers that we had put on school board property. My intention simply was to reach out to some of those members that I had dealt with in the past and ask them formally about this process to see what we could do in order to get this kid to march, due to the fact that so many family members were driving up from the Charleston area. If my informal contacts didn't work out, then I was instructing her to hire a local attorney to move further to maybe look into the matter further for her. I do admit that after I tried to contact the school board by phone, try to reach out to some of those people I had discussed business with in the past, had failed, I sent an email out. Unfortunately for me, I neglected to include on that email that I was only licensed in Georgia. That's a mistake and an oversight that I admittedly made. And in hindsight, I should have done it. But in the interest of time, I was just trying to get this letter out so we can try to get him to graduation, which is occurring at this point just days from this communication. The matter was ultimately dropped without my involvement. It was resolved by them directly between the principal and the parent, who is a cousin of mine. And it was then just dissolved and he was allowed to graduate. This, of course, will never happen again. I admit that it was an oversight, not admitting that I was only admitted in Georgia. And I ask and request you to please consider dismissing this charge or the charges that were brought against me with this allegation, and accept this as a one-time mistake that I made that will never, ever occur again. Again, thank you for your time. And if you have any questions, I'm free to answer them.
Thank you, Mr. Washington. Do any of the committee members have any questions for Mr. Washington?
Walter Brock has his hand raised.
Okay, Walter?
Yeah, thank you. Mr. Washington, I'm looking at your email and I want to make sure I'm reading it correctly. This is your email that you sent on February the 4th this year at 11:09 a.m. And it says to Ms. Rucker, also let me note that once you receive a representation letter from the attorney, that is all the legal authority needed. Is that what you wrote in your email?
I don't have it before me, but if you're looking at one of my emails, it probably was. That communication, though, was regarding a phone conversation that me and Ms. Rucker had when I was trying to reach the school board superintendent and get an idea of who actually made the decision. And she told me that, I think we're having some technical difficulties. Can you all still hear me?
We can. I think Mr. Johnson is just sharing the content of your
sharing
email.
that. Okay. And she told me that parents were not allowed to be represented at all by legal representation before the Charlotte-Mecklenburg School Board. And she said that it just wasn't allowed. So I said, well, it's my understanding that if someone is hired by an attorney and they communicate that to you, then you should be able to communicate with that person. So that was in direct response to a conversation she and I had over the phone about the fact that individuals were not allowed to be represented by an attorney before the Charlotte-Mecklenburg school system.
Would you agree with me then that conveys to her that you're an attorney representing that person?
It may in and of itself, but in conjunction with the conversation that she and I had, I explained to her, because she and I had several different conversations after that, where she was trying to get me in touch with individuals. And I explained to her clearly that I was admitted. She knew that I was only admitted in Georgia. And I said to her over the phone that in the event we're not able to work this out, that she'll have to find someone local attorney to help her represent in this. And that I had talked with a couple of the attorneys before in the Charlotte-Mecklenburg legal department, and I was trying to reach them informally to address this. But that particular email was addressing the conversation she had concerning the fact that individuals were not, I don't know if that's true or not. I never did get an answer to that, but she said that a person cannot have legal representation before the Charlotte Mecklenburg School Board.
Okay, but that is your statement saying that once you receive a representation letter from the attorney being you, that is all the legal authority needed. That's what you were saying. Is that right?
To be honest with you, I'm not clear. Again, I thought that response was directed toward that, but I can see how it could be interpreted that way. Again, there were several mistakes made on my part. One being that I should have put on my letter that I was only admitted in Georgia, and two, I was only inquiring into this on an informal basis to try to get it resolved informally without any legal interaction. My client didn't pay any money. My cousin didn't pay any money, nor did she have any intention of paying me any money. It was just an informal inquiry on my part. Again, I admit that mistakes was made. I admit that I should have clearly stated that I was only admitted in Georgia, and that this inquiry was not in a legal matter, not from a legal position as me being an attorney there to represent her from a purely legal stance, but just as a person that had a legal degree that was looking into it informally for my cousin, just try to get it resolved without there being any legal interaction. But yes, I can clearly see how that could be interpreted as me indicating that. Yes.
Mr.
would
Chair,
you agree?
we have a
Any
few
other
hands up.
questions for Mr. Washington?
Yep, Mr. Chair, we have a few hands up. Julie Bell and Andrea both have their hands raised.
Okay, Julie, well, I'll call on you first.
Okay, can somebody put back up the email that was up just a minute ago, since Mr. Washington doesn't have it in front of him?
Just a second, Joe. Can you see it?
Yes, I can, thank you. Mr. Washington, can you see the screen?
Yes, I can at this point, yes.
Okay, I'm looking at the language that starts Ms. Rucker. Can you read that email to yourself? And then I have a question.
Yes.
I'll give you a second or two. Let me know when you're ready.
Yes, I'm ready.
I think I heard you say a moment ago that you could see how this email could be interpreted as acting as her counsel. How can it be interpreted any other way?
Well, for one, these statements are all made in an objective manner. It doesn't say I will. When it talks about filing a restraining order, it doesn't say that I will be filing a restraining order. It didn't say that I would be doing any of these things individually for this person. I was trying to just simply set forth for Ms. Rucker what I thought were legal due process rights that this person should be entitled to. I never want her to assume that I would be the one doing these things, that I would be the one filing a restraining order. But the fact that I felt that the school board, from what she was telling me over the phone, was not allowing her proper due process. That was my intention. It may not have come across that way, but that was my original intention.
Okay, I don't have any more questions.
Andrea?
You hear me?
Yes.
I move to dismiss this case.
Got a motion to dismiss. Is there a second?
Second.
Was that a second?
Yeah.
Okay. Any further discussion or questions for Mr. Washington at this time? All those in favor of the motion to dismiss this matter, please vote by indicating yes. And all opposed to the motion to dismiss, please vote by indicating no.
Mr. Chair, you have, well, I'll let any other votes coming in. Right now you have a vote of 10 yeses and 10 nos.
I vote yes, but I can't, you turned off my thing.
I know,
I'm unable to
because
vote.
we're still sharing the screen, we can't find our thing.
Okay, David, can you turn off screen sharing?
There you go.
Yeah.
There we go.
All right.
Let me, I vote yes.
All right, if all votes are in, we have 12 yeses and 11 nos.
I vote no, but I don't have a button to select.
That would make it 12 to 12, Kevin.
Okay. As a matter of protocol, I voted. So what, should the chair have voted or not?
You're allowed to vote, Kevin.
Okay, so we got 12 to 12. And so the motion dies. So the chair would entertain a different motion.
Kevin, it's Walter. I move for a letter of caution.
Okay, motion for a letter of caution and a second. Any
May I-
further?
May I make an amendment to your motion, Walter? If we could say that our letter of caution is not put it, that it is with probable cause, just say it's look out.
I'll consent to that amendment.
Okay.
Sounds good to me.
All right, so we got a motion. Is there a second with that amendment?
Second.
All right, all those in favor, please vote by indicating yes. And any opposed, please vote by indicating no.
Kevin, you have a vote of 20 yeses and 2 nos.
All right, so the motion carries. Mr. Washington, again, thank you for joining us this morning. And as you will be receiving a letter from me as the chair of the committee. So thank you.
Thank you for your time.
All right. Let's move to Mr. Carabas, number 22, if we can get him from the waiting room.
Yes, I'll admit him. David, do you want to give a quick update on Ms. Alexander?
Yes, we've been trying to get in touch with her by email and phone. The phone says she's not accepting calls and no response yet to the email. She has not tried to get back into the waiting room.
Why don't we just give it a little more time and we'll see what happens with Ms. Washington, and then we can, Ms. Alexander, excuse me, and then we can decide what to do at the end of the meeting with her if we can't get her back into the room.
Mr. Carabas is in the meeting now, sir.
All right. Mr. Carabas, can you hear me?
Yes, sir. Good morning.
Good morning. My name is Kevin Williams, and I serve as the chair of the Authorized Practice Committee of the State Bar. And we welcome you to our virtual meeting this morning, and thank you for your patience. What I will first do is call on the State Bar Council to give a brief summary of this matter, and then we'll allow you to respond and address the committee.
Yes, sir.
Okay, Mr. Carabas is a Florida attorney, and he sent a demand letter and a completed arbitration claim to the former employer of his client and the purchaser of the real property of the former employer. And the dispute arose over the termination of the lease of the property of the premises as a residence to his client, who, correct me if I'm wrong, Mr. Carabas, I believe she's your niece. Is that right?
Yes. Yes, sir. She's my niece and goddaughter.
Okay. And so essentially the problem is that as a Florida attorney, whether or not he can represent a party in a potential arbitration proceeding in North Carolina involving North Carolina law, with the opposing party being North Carolina clients. The exception under our Rule 5.5 C of the Rules of Professional Conduct says that it is a matter that a lawyer can do so on behalf of a party who is from the jurisdiction in which he is licensed, but only as long as the services are not something for which pro hoc vici admission is required. Normally, we have taken the position that arbitration matters in North Carolina involving North Carolina law, North Carolina parties are essentially the same as court matters and would be something for which there would have to be pro hoc vici admission of some sort, some association with North Carolina counsel. So that's the circumstances here in this matter.
Mr. Carrabas.
Yes, thank you all for having me today. Thank you for Mr. Johnson for getting back to me through our constant emails. I really do appreciate it. A couple days ago, I didn't know that I'd be able to address a committee today. I just want to give you my background. Everything that Mr. Johnson said is absolutely true. I'm a former high school teacher. I've been a lawyer for approximately a decade. I'm a former assistant state attorney, a former special assistant United States attorney. I'm current counsel to the Broward County School Board in Florida. And Mr. Johnson's absolutely correct. This is all really coming from my niece's landlord dispute of getting her security deposit back, which I sent a letter to the person in North Carolina. My niece went to North Carolina in August of 2018, and then in March of 2020 came back. So she was never a North Carolina party, or she was never a North Carolina resident. She's always lived or been in Florida. I didn't know anything about this until she came home on March 27th, 2020. When she came home, she advised me that she was kicked out of the property and that she would not be getting her security deposit back. I understand the UPL laws, and I've done a lot of stuff. This is very scary to me once I got the letter, and I've looked up. I personally, in the correspondence that I sent to Ms. Brown, who was the other party, I in the last paragraph, I specifically put in there that if this had to go any further, that I would have to find North Carolina counsel, and I would have to potentially enter pro hoc vice. When I sent the demand, which was never filed, to the parties in North Carolina, it was after looking at Rule 22 of the American Arbitration Association. I fully thought, because it says anyone can represent, and it doesn't matter really if you're barred in that state or not. So I didn't know. Looking at past cases, Mr. Johnson was kind enough in an email to advise me that North Carolina often took the position that you had to be barred in North Carolina. I've looked at other states such as New York, New Jersey, Virginia, where you don't have to be barred to enter into arbitration because that's what our contract called for. So I never had any intent. I never held myself out as a North Carolina lawyer. I never had any intent to enter. I apologize, I'm nervous. To enter into a North Carolina tribunal or court. My letter says that I would have hired or gotten co-counsel in North Carolina. And even if it went to arbitration, I would have gotten co-counsel, but I just never knew that the American Arbitration Association, especially reading Rule 22, would have required me to have North Carolina counsel when my party was always a Florida resident and always a Florida party. I never filed the demand. I did send the letter. Everything that Mr. Johnson has said is absolutely true. This is absolutely a one-time incident. I was not trying to establish or get paid or have any clientele. This is something that came upon me when my niece came back from college. That's when I was aware of it. I don't really want to go through unless the committee wants me to. I'm assuming if I could just get a from Sir Chair, if you could just let me know that if the committee has my response, then there's really no need to go through it again with the pertinent facts and the case law that I I cited.
Thank you, Mr. Carrabas. All the materials have been
Okay.
provided to all the committee members prior to today's meeting.
Thank you, sir. So I don't want to waste everyone's time on that, but I do feel it is important to let you know that it was never my intent to practice law in North Carolina. It was never my intent to get caught up in this. I thought the American Arbitration Association allowed this. And again, I specifically put in my correspondence that if this had to go to litigation, that my niece, my granddaughter, would have to get North Carolina counsel. So it was never my intention to enter into or practice in North Carolina. And I did read over Rule 5.5, subsection C, and then comments 2, 5, 6, and 7. And again, I apologize for the committee to having to hear me today and take up your time. It was just never my intention. I've been an attorney now for give or take 10 years. I'm in my 10th year. I've never had a case outside of my jurisdiction, being an ASA and being a special assistant United States attorney. So when my niece came back from North Carolina, I never thought that sending a letter or sending a arbitration demand would have been construed as the unauthorized practice of law. Obviously, I've learned a lot in the past month, and I'm very sorry about that.
Mr. Carrabas, thank you. Any committee members have any questions for Mr. Carrabas?
Mr. Chair, we have two hands up. It looks like Mark Enriquez was first, and then Warren Savage was second.
Okay, Mark. You're muted, Mark.
Good morning, everyone. Mine is more a comment than a question for Mr. Carrabas, but I agree with him. I've looked at some of the decisions in New York and New Jersey, and I actually am persuaded that I don't think you should, that the practice in arbitration is the unauthorized practice of law. And I think if we go back to our fundamental principles of trying to protect the public, I think having a lawyer represent you in arbitration where you don't even have to be a lawyer at all, I don't think a requirement that you be North Carolina barred in that circumstance really does serve a protect the public purpose. But at a minimum, I think it's confusing when you look at the North Carolina comments. It speaks about requiring admission pro hoc vice, which is not required under the AAA rules. So after reviewing that authority, we may or may not want to decide the bigger question of whether the arbitration is permitted, but under these circumstances, I think dismissal is appropriate. And after the comments, that's what I intend to move for.
Okay, thank you, Mark. Warren.
Mr. Carrabas, in the spirit of what Mark was just commenting on, do you know, this is a question I think you're not the only person that is confused about, and I would imagine other people on this call are, would a North Carolina lawyer or an Alabama lawyer be able to do a AAA, send the same thing in Florida? Do you know that for a fact?
No, sir, I don't know.
You don't? Okay. I was just curious because I think this is, there are other states, like you say, where you can do this without being admitted pro hoc. And it's pretty clear this was a one-off to me. I will join in any motion that Mark makes to dismiss.
Okay, before we consider a motion, any other comments or questions for Mr. Carrabas? Hearing none, seeing none.
In that case,
entertain a motion.
I move for dismissal.
Okay. Is there a second?
Second.
Any further discussion?
This is Walter. I just am a little concerned about the broad notion that arbitrations don't require counsel. I'm involved in arbitrations both in North Carolina and South Carolina, where I have gotten admitted for the limited purpose of the arbitration proceedings. In South Carolina, arbitrations can be as complicated as any civil litigation. So I'm a little concerned at the suggestion that arbitrations ought to be, as a general matter, something we don't consider requiring one to be authorized to practice. I think that's a dangerous precedent if that's what we're setting here.
May I comment?
Sure.
Walter, I certainly am not wanting this to be some precedent on that point. I think given the context of trying to get back a security deposit on your, while I know we don't have a family exception, but in the context of trying to get back a security deposit for a niece, that requiring an attorney to be paid, do a thorough, do all the only attorney she knows is her uncle or godfather, and that she then have to do a nationwide search on and research on, or at least to send a letter to get back that deposit. It just seems, in this case, I certainly think it's. Sorry, I'm just rambling now.
All right. Any further comments or discussion?
Kevin, Julie Bell has a comment.
Okay, Julie.
I would say, and I know this is a different case from the case we just heard, but the case we just heard involved a family member, somebody trying to do something for a family member who is a lawyer outside. And I would like to see us be consistent in how we handle those cases across people. That's my comment.
Okay. Thank you, Julie. Anybody?
Mr. Chair, I would comment in response to that, Julie, that here there's a little ambiguity as to the residency of the client. In the former matter, it was clear the client was a North Carolina resident involving an entirely North Carolina matter.
Thank you, David. All right, well, there's a motion to dismiss and a second. Any further questions or comments?
I would just add, Kevin, that I agree with Julie. I don't know how we can truly distinguish these two cases, and I think we need to be consistent.
Okay.
So I oppose the motion.
Anything further? All those in favor of the motion to dismiss, please indicate by voting yes. And all those opposed to the motion, please indicate by voting no.
So you have a vote of 15 yeses and 8 nos.
Okay, so the motion to dismiss carries. Mr. Carabas, thank you for joining us this morning. You will receive a letter from me as chair of the committee reflecting the outcome of the committee's vote.
Thank you, sir.
Okay.
And thank you, everyone.
Yep, thank you.
Dorothy has a question or a comment.
Dorothy?
Yes, please forgive me in advance for what I have to say. But I tried to vote. I seconded the last motion for Mr. Washington, and then tried to vote and got kicked off my internet. And then I tried to email and say I was watching from YouTube, trying to indicate via email what my vote was. But could you remind me what the vote was on the initial motion? I believe I heard it was a 12-12 initially.
That is correct. You talking about for Mr. Washington?
Yes, sir.
Yes, the initial vote was 12-12 on the motion to dismiss.
Right. So if my vote would have been included, it would have been a 13-12 then.
That is my recollection, and that would be correct.
All right. So I just wanted to note that because like I said, I was trying to get my vote, but got kicked off at the same time, and I did email it, but I don't know if is it possible for us to revisit? I know the second motion passed, but.
Under the circumstances, unless, someone can correct me, but under these circumstances, I think it would be appropriate. I don't think it would be inappropriate to reconsider that.
Okay. I appreciate it. And I apologize to everyone for that, but I was trying to vote. Especially since I seconded the motion and it got kicked off right after without being able to put my vote in.
I will say this, it would certainly make me feel better if we reconsider so that we can be consistent.
Yeah, the chair would entertain a motion to reconsider the matter involving Mr. Washington, unless there's a reason that violates some protocol I'm unaware of.
So moved.
All right, is there a second?
So moved.
Second.
All right.
Second.
All those in favor of the
Can I ask a
motion?
Can I ask a question before we vote?
Yeah, yes. Well, all we're doing now is just voting on whether to reconsider the matter or not. But yes, whoever just raised their hand.
So and I apologize, this is Joshua Malcolm.
Hey, Josh.
So this proposed motion that we're making right now, and it's been a long time since I opened up my little handy dandy notebook. Are we following the process that's set forth in Robert's rules related to that? Whoever the staff is supporting this committee, are we compliant with the process we're supposed to be using?
Well, I think we can move to reconsider something and then take another vote on it after we reconsider something.
If it makes you feel better, Joshua, committees reconsider actions all the time. It's just usually not this quick. Normally it's, a quarter or two later, a respondent will request for reconsideration, and then that'll first go to the chair and then the committee to do what we're about to do right now, and that's vote on whether to reconsider. And then if that passes, vote again regarding what to do. So it's something that happens often.
And is it appropriate for this gentleman that's on this case now to be involved in this conversation related to someone else?
It's a public meeting. And so if we were having it in a room, all the respondents would be in the room at the same time that we're talking about it.
Yeah.
Having said that, Mr. Carabas, I don't think there's any reason you need to be here unless you're just curious.
No, sir. I just didn't know if I was allowed to be dismissed from this, and that's why I'm still on, sir. I just didn't know if.
That's fine. That's up to the chair. Mr. Chair, I'll defer to you.
Mr. Carabas is afraid we might reconsider his decision.
Mr. Chair, I'd like to leave. I just didn't know if I was allowed to.
You are hereby excused to the extent I have the authority to say that.
And Mr. Carabas, it is a public meeting, so if you want to continue to watch, you can watch on YouTube.
Yes, no, sir. I just didn't know that I was allowed to leave. Thank you, everyone, for your time. I appreciate it. Thank you.
Thank you, Mr. Carabas. All right. As I indicated previously, and as Josh indicated, I think the appropriate protocol would be first to vote on the motion for reconsideration. So what you are now voting on is whether to reconsider the matter involving Mr. Washington, which was number 17. So if you're in favor of reconsidering the motion, please vote yes. If you oppose the motion to reconsider, please vote no.
You have 23 yeses.
All right. So now we will reconsider the matter involving Mr. Washington, and given Ms. Mitchell's previous comments, the chair would entertain a motion involving Mr. Washington.
I move for dismissal for Mr. Washington's matter.
Is there a second?
Second.
Any further discussion or questions?
Andrea, you're muted. Still muted.
Andrea, we can't hear you. If it's significant, type it in the chat function. Okay. All right. So we've got a motion to dismiss and an appropriate second. Any further questions or comments? All those in favor of a dismissal for Mr. Washington, please vote yes. And any opposed to the motion to dismiss, please vote by voting no.
We give a vote of 23 yeses and 2 nos.
All right, very good. Dorothy, thank you for bringing that to our attention. And with that, we will.
Me to do so.
Yep.
And I apologize again.
No need to apologize at all. With that, we will move on to the consent. We'll continue with the consent agenda, and we will move to matter number 10, which I believe Mr. Bundy wanted pulled for Seneca Jacobs. And I will note, I also think that Mr. Schneider represents Ms. Jacobs. And so at the appropriate time, the chair will recognize Mr. Schneider. But first, I'll let Ligon tell us why he would like this matter pulled.
Well, I agree with the recommendation of staff as to what we do, which was a letter of caution and referral to Tennessee Board of Professional Responsibility. The thing that concerns me about this, though, it appears to me that his residency was an important element of this, and the staff did a good bit of research. And the thing that concerns me is that staff determined that he is registered to vote in Red Springs, which I think is in Robeson County, and that he is also registered to vote in the state of Arkansas. I'm no expert on voting law, but it would seem to me that there's certainly an aroma of possibly even criminal activity here. And so it occurred to me that perhaps we should refer this to the appropriate Board of Elections, probably being the county board where Red Springs is, for them to just to give them a heads up and for them to do whatever investigation they deem to be appropriate. So that's my concern. And
David,
I would make that motion if there's much appetite on the rest of the board members to support that.
David, any comments based upon your research?
I'm not sure I have anything to comment other than what I put in the report. He clearly registered to vote both in Arkansas and in North Carolina. Whether or not we want to contact the boards of election concerning that's really not a matter for this committee's concern primarily, but we can certainly make the referral. I don't know if Alan has anything he wants to comment on that.
Yeah, let me recognize Alan.
I'm not familiar with the voting yet, as far as issue where he is registered to vote. So and I'm just prepared to address any AP concerns as it relates to that.
Okay, thanks, Alan. Any other questions or comments involving this matter? I think we've got
Josh,
got
Malcolm, and Brandy Vickery.
All right, take them in reverse order. Brandy?
Yeah, I just wondered if anybody's noticed whether he's voted in Robeson County recently. I mean, I want to make sure I feel comfortable knowing this isn't a situation where he just moved and, moved to another state. You don't have to tell anybody that, I don't guess. But if he's been voting, I think it changes my.
Yes, I put in the report, as I put in the report, he voted in the 2016 general election in Robeson County. But prior to that, he had not voted in 16 or 18 years.
And the report also indicates that we don't know from the Arkansas records what elections he has or has not voted in, correct?
That's correct.
Right.
Okay.
And then Joshua Malcolm has a hand up.
Yep, Joshua?
Yeah, I'll say, Mr. Bundy, I know a few things about election law, unfortunately. I would recommend that perhaps if you're going to move forward with the motion, that the motion would in fact be that we direct staff to review the election law and make a referral in accordance with the statute. It may in fact not be the county board. There may be some language that talks about the state board, but I don't know that I would make it as specific as that. If that's the desire of this committee to refer anything, you may want to make it a little more because the state board is really responsible for those type matters. That's my only comment.
Any further questions or comments? Ligon?
I'll just put it out there. I would move that the staff review this matter and with a view towards considering referring this matter to the appropriate North Carolina Board of Elections.
Mr. Chair, Warren Savage has a raised hand.
Warren?
Just a question in general about, if I have a son who was registered in North Carolina and just moved to Washington, D.C. and registered. Is he technically registered in two places? And that's okay, as long as he didn't vote in North Carolina in the last election while he was in D.C.? Or does D.C. notify North Carolina, or is he supposed to notify North Carolina he's no longer registered there? I guess that's kind of my question. I'm not sure in my mind, if somebody moves and registers in a new place, that they're no longer, that they wouldn't be considered registered in the old place anymore until they try to vote in both places. That's my only comment.
So from the facts that we know, it appears that we know he's registered in two different jurisdictions. There's no evidence before the committee, at least today, that he has voted, in the same election in two different jurisdictions, but we don't know that. So we've got a motion from Mr. Bundy. Is there a second?
Second.
And who was that?
That'd be Jerry.
Oh, hey, Jerry. Thank you.
Mr. Chairman, can you tell me what the current motion is it's on?
The motion, as I understand it, is a motion for a letter of caution with direction to the staff council to review the appropriate election laws and consider making a referral to the appropriate governmental agency that oversees such things in North Carolina. Is that a fair characterization, Ligon?
Yes. It was also the staff had recommended a referral to the Tennessee Board of Professional Responsibility.
My apologies. Yes.
Before any referral with respect to the Board of Elections, once staff does their further research, would Mr. Jacobs through council have the opportunity to address any concerns at this level before that referral was made?
So you're sort of hitting on a place of uneasiness for me, and maybe I'll ask David this question: is the staff's not going to make a referral without this board, without this committee voting, directing the staff to whom to make the referral? Is that correct?
That would be my inclination, yes.
I don't know. I was a little bit uneasy about Ligon's motion by voting to leaving something up to the staff when it's our prerogative to vote on to whom a referral gets made.
Would the committee entertain the thought of possibly continuing this till the next meeting and addressing this all together once staff has done further research on the issue?
Mr. Chair, there's a motion on the floor. I think we either have to debate that motion and call it to a vote or not.
I think that's right. Let's handle the motion.
Could I make a statement? Could I make a statement? I'm the one that started all this up, and I'm certainly not wanting to send the staff on a wild goose chase trying to figure out what the elections laws are and whether this gentleman has violated them. From reviewing the materials, though, it appeared to me that he's registered in North Carolina and has voted in North Carolina fairly recently, and he is also registered in another state. Those facts standing alone wouldn't cause me great concern, but there's certainly a flavor here that he has misrepresented to the court where he lives. When he filed his motion for admittance into North Carolina, he indicated that he lived, I think, in Tennessee, And then it turns up he lives in Arkansas. And he's been less than candid concerning other matters. And it just seems to me that when it comes to the attention of the bar, that someone may be engaging in illegal activities, other illegal activities, that we ought not just ignore it. So, and I'm not quite sure what's the best way to address it, but I just don't feel comfortable with just letting this slide in view of his other misrepresentations concerning where he lives. That's my concern.
Mr. Chair.
Ligon, in light of that, would you consider withdrawing and or amending your motion to allow the state bar to further investigate where a potential referral would go, and that this matter come back to us at the October meeting?
Yes.
Mr. Chair, Branny and Tom have their hands raised.
Okay, Tom, I'll call on you first.
I wanted to just a clarification on what the motion, because there was some reference about the AP aspect of it. And so we're not dealing with the AP aspect of it. We're nearly dealing with whether there's some other action that the committee needs to take, if I'm understanding the motion properly.
Well, I think the motion was to,
and it may have just been changed.
So let me answer your question, and then I'll tell you where I think we are. I think the motion was to adopt the committee's or adopt the staff council's recommendation on the AP issues, but in conjunction with that, to look at the matter further to see if it needed to be referred to a different governmental agency based on a potential registration issue. My concern with that is I don't think we can give the staff kind of advisory guidelines. I mean, we either vote yes or no on making a referral or not. And if we need additional information, it seems more appropriate to me that we direct the staff to go find that information and then bring it back to us for a vote in October, which is why I asked Ligon if he would be willing to change his motion to address it all in October once we get the questions answered. And he said yes. So I'm not sure that I'm not sure that's exactly where we are, but I guess my concern is I don't think we can vote to instruct the staff council to go investigate something and then make a decision on their own as to whether or not to make a referral. Brandon,
That's my concern, is conflating the issue, because what if the voter registration is nothing but an oversight, and he's not violated any law. And I think that may, if I understand Ligon's concern, that may impact how we deal with the AP issue as a committee.
Correct. And so I think what my suggestion would be is if we're going to table it, we table the whole thing until October.
And
that
would be consistent with my request, that we consider the whole thing together, because I would like to address, I think one does impact the other, and I would like to address some of the comments and concerns about misrepresentations. And I think doing it all together would be my preference, but I'll defer to whatever this committee decides.
Okay, Brandy?
Well, that kind of addresses, I thought we were getting ready to vote on issuing a letter of caution plus. And I want to make sure Alan got to be heard, because he had deferred on the criminal aspect, but he still had not wanted to. He did want to make a pitch, I'm sure, on the AP issue.
And Mr. Chair, Andrea's hand is raised.
Who did you say?
Andrea.
Andrea?
Can you hear me?
You can.
Okay, so he's licensed in Tennessee, right? And
He is licensed in Tennessee.
So I guess my question is, if it's an issue regarding truthfulness, then why don't we just make it simple and refer it to the Tennessee bar and let them decide whether they want to pursue it? I don't feel like the North Carolina bar should get into issues that really affect his license to practice law and whether or not he should be, whether he should be reprimanded or something like that. I feel like the simple thing would be to just refer it to Tennessee and let them decide whether they want to pursue it.
And Andrea, I agree 100% to the extent that this committee decides after exploring the other issues and addressing some of the AP concerns that with respect to any allegations regarding misrepresentations, not whether or not he was eligible for the Pro Hoc Vici in the first place, but with respect to any allegations of misconduct, I think Tennessee would be the more appropriate forum to address that particular issue. But I think some of the issues that need to be addressed by this committee might impact that referral. But all I was saying is I would love to address all of those issues together, including the research that Mr. Johnson will do on the voter registration issue, as opposed to doing it piecemeal.
That's all I had. Yeah.
Okay. Anybody else have a question or comment on this matter? So where I think we currently are, and Ligon, correct me if I'm wrong, is essentially a motion to continue this matter to October with direction to the State Bar staff to conduct some additional research as to any other information that can be found with respect to the voter registration issue and to which governmental agency such a referral would be made if this committee decides to make such a referral.
That's correct.
Is there a second to that motion?
Second.
All right, any further discussion? Any further discussion whatsoever? All right, all those in favor of that motion, please vote by indicating yes. And any opposed, please vote by indicating no.
It's like
You have
25
yeses and 0 no's.
Okay, so we will reconsider this in October. It also occurred to me, before I forget, David, will you or someone else be sure to contact Mr. Washington today to let him know that, after he exited our meeting, that the committee reconsidered his matter and that it is going to be dismissed? I'd like to let him know that as soon as possible.
I can do that, yes.
Okay. The other matter, at least according to my notes, that Mr. Bundy and perhaps someone, and I think Mr. Savage wanted pulled, was number 12 involving Mr. Jimenez.
Mr. Williams, may I be excused?
Yes, well, you may, although there was another matter I think you're representing someone on, but I think we'll deal with that as part of the consent agenda. So
right,
if you're comfortable, yes.
And I was comfortable with that, the disposition in that matter. I don't need to be heard unless people just want me to be heard.
Oh, good. Thank you, Alan.
Thank you so much. I appreciate your time.
Bye-bye. Be safe. Warren, I'll call on you on this matter first. I think you were the first to indicate you wanted this one pulled.
Thanks, Kevin. So I guess this one was just one where I was concerned about whether we needed to bring it with caution. A letter of caution with a finding of probable cause. It sounds like more of a misunderstanding and rather than an intentional misrepresentation. And as soon as it was brought to his attention, it was corrected. I'm afraid that's probably happened before when laterals are hired from other states that people put things out there. I know we had one on these on a prior agenda, and I would just prefer in this type of situation if we could, there's no argument that he made once it was brought to his attention. And I would just say I'd like to this to be without a letter, without probable cause.
Okay. And Ligon, you also asked this to be pulled. Would you like to be heard?
Well, my only concern, my only comment is that we're also dealing with a law firm of attorneys licensed in North Carolina, and they allowed their internet listing, their website, to solicit business on behalf of a non-licensed attorney. and which is not something for the Authorized Practice Committee, but I question whether that's something for the Grievance Committee to address with respect to these other attorneys. And it may, it may have just been inadvertent, and we should not do anything about it. But I just that concerned me a little bit.
Okay. Any other questions or comments on matter number 12? Okay, at this time, the chair would entertain a motion. And Warren, did you want to make the motion that you referred to earlier?
Yeah, I'd like to make a motion that we issue a letter of caution without probable cause.
Mr. Chair, I apologize for jumping in. Tom has his hand raised.
Okay, Tom.
What's his current status? The documentation is dated back from February. Has he been admitted into the bar in North Carolina yet?
I do not know.
Okay.
Any other questions or comments? Okay, we got a motion from Mr. Savage. Is there a second?
I'll second the motion.
Okay, who was that?
Mark Enriquez.
Thanks, Mark. Any further discussion? All those in favor of the motion to issue a letter of caution without a finding of probable cause, please vote by indicating yes. And any opposed, please vote by indicating no. Okay.
We have 24 yeses and 1 no, Mr. Chair.
All right, motion carries. Thank you. For the remainder of the consent agenda, the chair would entertain a motion to adopt the recommendation of staff counsel for the remaining items on the consent agenda.
So moved.
Okay, who
So
was that?
moved.
All right, is there a second?
Second the motion, John Woodardson.
All those in favor of adopting staff recommendation for the balance of the consent agenda, please vote by indicating yes. And any opposed, please vote by indicating no.
Mr. Chair, we have 25 yeses and 0 nos.
All right, thank you. Motion carries. And then let's circle back and see where we are with Ms. Tammy Alexander. Any update?
We have not heard from her further since she dropped off.
The chair would entertain a motion to continue the matter involving Ms. Alexander until October. I think that would be most appropriate since she wanted to be heard, and for technical reasons, we just can't get her today. So I think it would be most appropriate to not consider that matter today and to postpone it until October.
So
So
moved.
moved.
So moved.
Is there a second?
Second.
Second.
Any discussion? All those in favor, please indicate by clicking yes. And any opposed, please indicate by clicking no.
Mr. Chair, we have 25 yeses and 0 nos.
Okay, so the Ms. Alexander's matter will be continued until October. Any other matters to come before this group today? David, Josh?
No, sir. I have learned, though, that I need at least 4 or 5 screens in order to keep up with everything.
This is a challenging exercise for sure. But thanks everybody for your patience. You never know where the twists and turns are going to come from as we live in this new normal. So thanks everybody. I hope everybody is safe, well.